an employer needs help with in managing their employees, we work with them to make sure they're doing it legally.
So this is a perfect guest for you because of HR.
And some of the things we've been talking about that come up in the workplace, we talk a little bit about how to avoid what's right, what's wrong. Katie gets the part that, when things don't go right and they bring it to that next level. Hello, Katie.
Oh, yes. I become very important at that time.
You become important, and I'm sure in today's day and age, everything is legal. I mean, you got to be careful about everything you do, especially in the workplace.
Correct. Absolutely.
You must be busy a lot.
Yes, absolutely. A lot of employers, they don't take the time early on to make sure they're doing everything in compliance, and then all of a sudden they get a lawsuit filed or an internal employee complaint, and then all of a sudden they're realizing, all right, well, maybe we haven't done everything perfectly. So not only do they have to deal with the employee complaint, but they need to go back and look at how they've been doing things and their practices and policies and fix them. And so I help them with both of those aspects.
Because the laws change a lot, don't they?
They do.
With employment.
Oh, absolutely. The laws change, and also when you're looking at agencies, the focus changes. And all of a sudden, little laws that we haven't even thought about for the last 10 years become very important. And so it's nearly impossible for employers to stay up on top of everything that's going on in the employment law arena.
And that's where you're busy, Michelle.
Correct.
Constantly changing compliance, policy,
Right. Keeping all of my employers on top of the latest changes and so forth is absolutely critical. And when Katie mentioned, different agencies, we're talking about Department of Labor, could be Employment Homeland Security, it could be the IRS, it could be a variety of different federal and state agencies.
OSHA?
Yeah, absolutely. Yeah, absolutely.
So it's craziness. And everything gets lost in translation, too.
Oh, absolutely. There's a lot of laws are open to interpretation, and sometimes courts and agency guidance that comes well after the law's on the book. So oftentimes there's a period of time where we're all thinking, what do they mean by that? So it's up to us to kind of do our best to, be conservative in how we're interpreting laws and making sure that our employers are doing the same thing to avoid penalties, fines, or litigation down the road.
Now, do you represent the employee or the employer or both?
I generally work with the employer and helping them to manage their employees the best they can so that there's no litigation later.
Do you see a lot of lawsuits coming through employee versus employer? Do you see discrimination or age discrimination or pregnancy or any, do you see a lot of that?
Absolutely. Some of those come in the form of agency filings in New Hampshire. If you have a discrimination claim, you're at the New Hampshire Human Rights Commission. Other times it comes in the form of litigation depending on what the claim is. But certainly I think there are a lot of claims out there, and I think they're on the rise, particularly when you look at how the economy has been in the last few years. There are more people who are losing their jobs, and warranted or not, there's a related increase in claims against employers as related to those terminations.
Can you explain that to me, okay? And we were discussing this before we came on. So many people, and this, I think it's very subjective, but this at will, who is it really protecting? Is it in protecting the employer? Is it protecting the employee? Or neither?
Well, I think the theory behind the at-will employment is basically what it means, first of all, is that either the employer or the employee can terminate their employment at any time without notice, without a reason, without cause. I think the theory behind it is that the employer can say, all right, you're not doing a good job, we're done here, and not owe the employee anything from that point on. And the theory is also that the employee can leave and not owe the employer a couple of weeks of extra work, and they can say, I'm leaving today and we're done here and our relationship is terminated. I think the reality is it probably does protect the employer a bit more because it gives them the sense that they can terminate an employee's employment at any time for any reason. The reality of at-will employment is that it's limited. Just because we are an at-will employment state doesn't mean that you can terminate an employee's employment really for any reason, because you can't do it in a discriminatory fashion. You can't say, all right, well, now I only want younger workers in my business, and so it's an at-will employment state, so that means I can terminate the older workers. So there are limits to it, and I think sometimes people misunderstand the at-will employment relationship and think it means they can kind of do whatever they want. There are limits. You can have an employment contract that says, I'll give 30 days notice, or I won't terminate you, and I'll give 30 days notice if I do, or I'm going to hire you for a period of a year, and then if you terminate them a month later, you still owe them pay for a year. There are limits, and I think people misunderstand that sometimes.
What happened to the days of being laid off? I mean, you can't even use the word laid off anymore, right? Because it used to mean if you were laid off, you could be brought back once, especially in construction, that kind of industry. They lay you off, you collect unemployment for a certain amount of time. Then there's teachers. It used to be teachers had, they could collect unemployment. That doesn't happen anymore.
Yeah, I think it's true. I think certain industries do somewhat still use the term layoff. I think the industry, as you mentioned, particularly construction, manufacturing, but generally these days when you hear the word layoff, it doesn't mean permanent. What it used to do. It used to mean, right?
Remember those days?
People. It scares them.
Michelle, it used to be, we're going to lay you off.
Right.
But they knew that they had, they were going to be protected because they had their unemployment insurance, and then they could come back, when it was seasonal kind of thing.
So we have temporary layoff and we have permanent. Is really what we have now.
Yeah.
And, the temporary layoffs, they're still entitled to unemployment benefits. But I do agree. I think the whole layoff term scares people now.
Oh, absolutely. Because it means, I know if I was here, the buzz in my company, there's going to be a lot of layoffs. Mm-hmm. The company's not doing well.
Right.
And with this economy, this is how there's been a lot of layoffs.
There has been, but I think we're also on the upswing of that.
Absolutely.
I'm hearing a lot of great things. I'm hearing how difficult it is to fill a lot of positions, which kind of leads into, how Katie was saying about, some of the things that show up in the courts nowadays are, age discrimination. Some of our older workers who can't get back into the workforce, or people who have been unemployed for 6 months or longer can't get back into the workforce. When you're out of work for a long time, and we've talked about this on previous shows, when you're out of work for a long time, your mind starts thinking, I'm not worth anything, nobody wants me, and then you go for these jobs, you're fully qualified, or you think you're fully qualified. Your mind starts playing, they didn't hire me because of my age, they didn't hire me because I'm Hispanic, they didn't hire me because I've been out of work for. So, those are things that start sitting with people. But fortunately, not fortunately, but those are probably more of the situations that come up now with people who aren't being hired, is that they're automatically assuming that it's something about them that is making that decision not to hire.
I see it now. My daughter was she had a fabulous job offer in the beginning of senior year of college, and she accepted. And as we got closer to graduation, things started changing with this company. And, suddenly the $60,000 job is going to entail you have to go to India in order to work for us. And she didn't, given today's what's all the stuff going on, she didn't feel safe, nor was her health good. So she rescinded on the offer and asked the company, well, did it mean that you hired me because it was contingent on me going to India? And they said yes. So, it's...
But did they lay that on the table before they even made the offer to her?
No, I don't think they did.
So this is where we get into some of the requirements of employers to lay all of the information out before an offer is put out there. so that employees or applicants, candidates, have that information to make their decision. And there's no surprises like that after they've signed a contract and said, sure, I'll take the job.
Right.
And then we hear, well, okay, and now you have to do this, this, and this. That's not fair.
Right. Absolutely.
From a legal standpoint, does she have a leg to stand on? Rescinding the offer because they were not upfront that it was contingent on her going abroad.
Right. Well, I always warn my employers when they're making offers. You can be bound by anything you say verbally. And then on the flip side, what you're talking about is when you don't provide the detail of the job offer. Whether there's some kind of legal recourse is often very fact specific, and I don't know the answer. But what the issue could be is, are they, do they give certain people the information they need to make the job and other people not? What employers need to be careful about when they're making job offers and they're putting together offer packets, are they treating everyone the same? And that's true at the stage where they're hiring the employees, when the employees work there, and when they're terminating employees. At all stages, employers have to make sure they're treating everybody equally.
And with that, I'm going to throw it over to Michelle to take us to a break. Come on.
What would you like me to say?
Say we're going to a break?
We're going to a break, everybody, and we'll be right back with Katie Marble from Marble Law Firm. Welcome back to 2GsinthePod. This is Michelle Gray with HR Synergy and Glennis Citarelli with Sweet Shot Photography. And we are here with our guest, Katie Marble from Marble Law Firm. And I just want to put something out there, a little disclaimer. Any information that you hear on the show this morning regarding employment law and advice is not really advice. It's, we're just talking about hypothetical situations that occur, and what happens in my world, and I'll let, Katie speak for herself, is, our role is really to be the neutral partner and to look at what is required and help our employers understand what that is, what they need to do to be compliant, and at the end of the day, it's their call. So I now hand it on over to Katie, who might have a little bit to add to that.
Yes, absolutely. I just want to reiterate that anything I say today is should not be construed as legal advice. When it comes to employment law, like so many other laws, it's very fact specific. So general advice really cannot be applied to specific situations at all. And if you have any issues, you should contact your legal counsel rather than rely on anything that is said today.
Excellent.
Or start off with your HR department.
Bingo.
Right? If you have an issue,
Absolutely.
go to your HR department.
Yeah. And I have my employment attorney that I confer with on various things.
Would you say, Katie, that as a legal standpoint, do most big employers, BAE, well, no, that's too big, but a medium-sized employer, do they have legal counsel usually to on their board or on their time card to help them out?
I would say most medium-sized employers probably have a good-sized HR department and then outsource their legal. A company like a BAE is going to have an in-house legal team. And then when you start looking at smaller companies, it's sort of probably 50-50 whether they have in-house HR even. And that they probably are the ones that will outsource to somebody like Michelle, who can help them out. And then they certainly don't have anybody on staff in the legal area.
Yeah, because we talk about that a lot. Small businesses, entrepreneurs trying to start up. Things like getting into copyrights and stuff like you need legal advice.
Oh, absolutely.
You can't do it.
You can't do it all.
You
can't do it all.
You can't. So, but specifics. We go back to what we started talking about because the gray area here for both the employee and the employer is what is at will. When is it okay to fire somebody because don't you have to give them warning? Don't you have to give them put them on notice that, okay, you did this? If it's done again, we're going to have to let you go. That's the way they used to do it. The pink slip. Is the pink slip gone?
I haven't seen a pink slip, I think, in a long time. I would say in terms of the process when you're dealing with employee discipline, the starting point is typically the employer's policies. Usually an employer will have an employee handbook that details how they're going to deal with employee discipline. That's not always the case, and if there's no policy, you usually look at past practices and how you treat employee discipline, and whether you have a progressive discipline, meaning you start with a warning, a verbal warning, written warning, and then escalate to termination. That is probably not used as often as it used to be. And it also depends on what the employee did. What was the reason for the discipline? If it was something significant, like stealing money, you're going to escalate right to termination. If it's, we need to work on how well you're doing your job, you'd probably start off at a lesser level, like a warning. Some companies don't have those policies, and you have to look at the practices. No company is obligated by law to follow a progressive disciplinary policy. Sometimes it's just a good practice. But there's a lot of leeway given to employers in how they handle those internal disciplinary issues. What I always talk to employers about when they call me saying, all right, we have somebody that we'd like to terminate. What do we do? How do we do it legally? There are a couple of things I look into. First, is there a contract? That's always important to know what the obligations are contractually. If there's no contract, you look at the reasons for the termination. Are they following their policies in the termination? Have there been any recent claims? Is it that, last week Susie said, I think I'm being sexually harassed, and now you want to terminate her? Okay, that's a huge red flag, and we're not going to do that. Right. So there are other issues. And the final one I always talk about is, do you treat other employees this way? If you had a man and a woman does something wrong, would you also terminate the man if he had did the same thing? So there are, certain areas that you have to walk through and consider very carefully if you're an employer before you actually decide to fire an employee, to make sure that you're doing it properly and in accordance with the law.
And as the employer, you've done everything, possible to stay in accordance to the law, to labor laws, and you terminate an employee. I'm thinking of an instance that actually happened to me. They terminated me after I was with the company 2-3 years. I don't even know what I was terminated for. I asked that question. I said, why are you terminating me? We've had a very good relationship, blah, 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 blah. Well, it's, we just don't think it's working out. That was the excuse they gave me. I said, okay, fine. I would like my employment file, because I wanted to see, was there something, and that's my right. Is it not, as an employee, I have the right to my file?
You do. Absolutely.
And they have to give it to me.
Yes.
Well, in this instance, they said, no, you can't have it. I said, oh, yes, it's my right to have it. Because I knew certain laws because of being my own business, owning my own business. So, make a long story short, I had to wait for them to put my file together.
That's not uncommon, and a lot of companies have a set policy. I'm sorry to kind of just jump in here, but a lot of companies have a set policy that it takes a certain period of time for an employee to get their file, one of which because, they're in the middle of business operations and they do need to prepare for that. So is it necessarily that they're hiding something in your file or, want to make sure? No. It's not that. It's really a matter of timing and being able to get that done. So they may say it's going to take up to 24 hours, it's going to take a week, but they should have a policy in place because it automatically sets that assumption for people that the employer is trying to hide something even when they're not.
Right. And I think there's a misperception about what your personnel file is. You know, a lot of people think, well, oh, there's a file in a drawer somewhere that is my personnel file. But it's broader than that, and it may be emails or memos that aren't necessarily in hard copy that need to be gathered. Or there may be that your manager had documents about your performance that maybe should have gone to HR to go into the file but didn't. So they do need to do some due diligence to make sure that what they're producing to you is actually your complete personnel file.
Interesting. What happened to the days where they would see? So much has changed.
Well, we have
since
so
my
much
days.
electronic capabilities
Well,
now
that's
too,
what- yeah.
and that's like Katie is saying. You know, they need that time to put things together. So think of if this escalates to the next level and maybe you file a suit, you have this employee file that's very different than what's presented in court.
Mm-hmm.
Okay, and all of a sudden it's like, ooh, where did all this come from? So it's fair for the employer to have that time to gather all of the data to make a complete file that is no different from what you would have gotten here versus what they would present at any type of hearing.
See, and back in the day, before all of these, before electronic email and anything going online, basically, that's what it was, things were simple. If you weren't performing, if it was your job performance, you were given warnings. And every warning you had to sign, as the employee, you had to sign. If you, Michelle, were my boss and we're not very happy with what you keep coming in late, and, we would have to sign, as the employee, I would have to sign a document saying, yes, they did bring this to my attention, and yes, I do agree. I have been late. I can't lie. Then you also had the right not to sign it if you did not agree with what your employer was saying of your performance. They don't do that anymore.
No, they don't. And I think more or less today, I encourage all of my clients, when you're having a performance conversation or expectation conversation with your employees, it's documented, and they sign whether they agree or not. If they don't agree, they're welcome to put comments as to why they don't agree on the bottom. But you have to document nowadays every conversation pretty much that you have with an employee. So, yes, back in the day, a progressive discipline policy would say, these are the steps you're going to follow. But sometimes there are circumstances that are a little different that make it difficult to follow those steps. And that's where it gets a little complicated, and you should talk to an attorney or your HR department or something like that to really figure out, should I even have this policy? Do I want a little more flexibility? But I understand I have to be consistent. I have to think about how I would have handled this, how I did handle this situation in the past, how I would handle it going forward, and all of those types of things. So, it's pretty tricky.
And I want to mention something that you raised earlier, which was that oftentimes employers don't give the reason for the termination when they actually have the termination meeting. And that's something I don't like. And that whenever I work with my employers, I counsel them, you have to be honest. Because if I go into a meeting with somebody who is over 40 or part of a protected category in general, and they're given a vague, it's just not working out, they don't buy it. They're not stupid. They know there's another reason for it. And it may be something as simple as you're not performing well. Well, if you don't tell them they're not performing well, they're going to think, well, is it because I'm a woman or because of my age or because of my race? So as a good practice for employers, it might be tough to tell somebody, you're not doing a good job. I get it. You don't want to have that conversation. You don't want to insult somebody. But you also don't want to be in litigation for the next 5 years because you just couldn't, gather the nerve to be honest for 5 minutes. So I think it's very important for employers to give the real reason for a termination, just as a method of protecting the business later on.
And it's actually just accepted in the business that you're sitting at right now, broadcasting. They can decide tomorrow, your ratings aren't good enough, Mr. Glendale, goodbye. Or we actually can in our business, well, we want to hire a Latino under 40, goodbye. And I really don't have a ground to complain about. I should in general be aware of the station's ratings, And I should, in general, know that therefore they're not hitting the profit margin they want. And they can hire a different demographic and sex and whatever as an attempt to improve their rating. So it's we didn't get the performance we wanted. They didn't say I personally was late or drinking on the job or whatever, but it's going to be sudden. It's going to be turn your key in at 5 o'clock, because unlike some other jobs, well, we can't have you on the air for 2 weeks whining, as you're going out the door.
Well, that's true, too.
So I'm all done. Or the anchor of Channel 7 News. If you're the 4th-rated 6 p.m. news, you just come in one day and your cubicle's being cleaned for you. I mean, you might have a nice contract in terms of severance pay, but you're done with the job, and the quote-unquote cause is because you're not number one.
I think the entertainment industry is a whole different animal.
I was just going to say
And it
that.
actually sounds like, Tim, you know what's expected of you. So your employer has made that
done his
pretty
job.
clear.
Yeah. What about, I'm thinking of something now, as a sole proprietor, I can't afford to hire an employee. I as much as my business right now, I need it big time. I can't afford to, literally. So what I do is when I have big photography jobs, I bring on a, what do you call it? Independent contractor.
contractor.
There we go. Independent contractor.
Ding, ding, ding.
Do you have another 3 days to talk about that?
Well, that's see, and to protect me as I'm not his employer or her employer. I'm not their employer.
You might be and not realize it. I know Michelle and I have had a lot of conversations about this.
Because that's a big thing now.
Yeah, it's huge. Whether an employee is properly classified as an employee or an independent contractor is probably one of the top, if not the top, employment law issues right now. It's an issue at a state level and also at the federal level. And what makes it difficult is every state and federal agency who cares has a different test. In New Hampshire, the Department of Labor has a test that's different from employment security. The IRS has a test also. So you can't just look at one test and say, oh, okay, I've properly classified this person as an independent contractor. You have to look at multiple tests to make sure you're doing it correctly. And the state has made this a huge issue. I know I went to a talk given by the New Hampshire Department of Labor Commissioner where he said this is a moral issue. A lot of these agencies think that employers are bringing on independent contractors and calling them independent contractors solely because they want to get out of paying taxes. I don't think that's the case. I think it's more that a lot of employers just don't know the difference and they think they're doing something that's allowed but isn't. So I won't get into the details of all these fun tests, but I think employers just need to be very wary of bringing on independent contractors because I would say more often than not, significantly more often than not, and somebody who you're calling an independent contractor is actually an employee.
Right. And the other thing to consider there, not just about, taxes, but what if they got hurt on the job? So workers' comp plays into misclassification as well, and who's going to pay for that injury and the health care and so forth. So, there's a lot of things to consider when you think, oh, I'm saving money on payroll taxes, I don't have to pay workers' comp. It might cost you a little more in the end.
Right.
All right.
Shoot.
Here we go. Okay. We're being specific. Should I have... So I have been teetering... trying to protect myself. Mostly not so much, listen, I'll pay, I'm not going to break any law. I will pay the taxes if it's rightfully, if that's what I'm supposed to be doing. That's not my issue. My issue is I want to draw up a contract because I do not want it, they used to call it a complete, non-compete clause. This photographer who may be trying to build their own business and taking my clients, okay, how do I protect myself? I say, okay, I'm going to draw up an agreement. The old-fashioned, no, the handshake doesn't work anymore. So, okay, I want to put it in writing. A basic little agreement. This is what I'm bringing you on to as an independent contractor. What do they call it? A
1099.
1099.
Yeah.
1099. This is what I expect you to do on this particular job. and it is to go anything that in photography, anything you're shooting is mine. It's protected by my copyrights. So that doesn't mean it is your intellectual property, even though you have it on your camera. See, it gets into this whole, photography is a whole different ballgame.
Right.
Art.
So you also have to be very careful on how much you dictate to them how they do their job.
That's true.
That's a very important factor, and I'll let Katie get into it a little bit more, as we are totally both on the same page here. When you're looking at an independent contractor, some things, and we've talked about this a little bit, can they hold themselves out for employment with other people? Do you control how and when they do their work? And let's talk about this.